Hey, welcome to the deep dive. We are taking a look today at something absolutely foundational to a huge democracy, something that impacts millions, perhaps billions of lives, the fundamental rights laid out in the Constitution of India. You sent us a pretty deep stack of material on this, focusing specifically on Part 3, Articles 12 through 35. It's dense, yes, but as we've started digging in, it's become incredibly illuminating. This isn't just dry legal text. It feels like the real framework for how citizens and the state interact in the world's largest democracy.
Indeed. And this chapter, part three, is often called, quite rightly, I think, the Magna Carta of India.
Ah,
It represents a really powerful set of protections, principles designed to, safeguard individual liberties against state action. Understanding these rights is absolutely key to understanding the very nature of the Indian state and the balance it tries to strike between government power and individual freedom.
Okay, let's try and unpack this then. Our mission today is really to guide you through this material, pulling out the most important insights. We want to figure out what these rights actually mean in practice, who they apply to, what their limits are constitutionally speaking, and importantly, how they've been shaped over time, by court decisions and constitutional changes.
Right.
We'll explore where they came from, how they've evolved, why they're seen as so vital, but also, and this is crucial, look at some of the significant critiques around them, drawing directly from the viewpoints in your sources.
Exactly. We'll synthesize the key takeaways, highlighting specific articles, their nuances, and of course those notable court cases that have really shaped their interpretation and how they're applied, over the decades since the Constitution started. This deep dive is all about giving you a clear, comprehensive picture, exploring the depth and complexity without getting completely lost in the legal beads, but definitely appreciating the crucial details.
All right, let's start right at the beginning. Where do these fundamental rights actually sit within the Constitution, and, well, what inspired putting them there in the first place?
Okay, so the fundamental rights are primarily located in Part 3 of the Constitution of India. That covers Articles 12 right through to 35. Now, when the Constitution was being drafted by the Constituent Assembly back in the late 40s, the framers were looking at various constitutional models from all over the world.
Right.
A very significant source of inspiration for this particular chapter, Part 3, was the Constitution of the USA, specifically its Bill of Rights.
The first 10 amendments.
Exactly. Those first 10 amendments, adopted soon after the U.S. Constitution itself, they outline key individual liberties and, crucially, limitations on government power.
Ah, so that direct link to the U.S. Bill of Rights immediately signals that the focus is really on protecting individual freedoms and putting constraints on the government.
Precisely. And it's because of this core function acting as this Charter of Liberties, a check on state authority, that Part 3 of the Indian Constitution is so often, and I think accurately, described as the Magna Carta of India.
Taking it back even further historically, you mean the original Magna Carta, 1215 in England?
That's the one. That historic document, forced on King John by his barons, it's widely seen as one of the earliest written examples of limiting the arbitrary power of the monarch and asserting certain rights for subjects. So by drawing that parallel to the Magna Carta, the description really emphasizes that Part 3 serves a similar fundamental purpose, establishing principles and protections that are, well, superior to the ordinary day-to-day will of the executive or the legislature.
And your source highlights something else quite striking about the Indian list of fundamental rights compared to others, even the U.S. Bill of Rights you mentioned.
That's right. One of the most notable things is just how incredibly long and comprehensive this list is. It's far more elaborate, more detailed than the equivalent bits in other countries, including the USA. Instead of just setting out broad principles, it really delves into specifics and includes various exceptions and qualifications right there within the articles themselves. And fundamentally, these rights are meant to be guaranteed to all persons without discrimination. The aim is promoting equality, respecting dignity, serving the public interest, and ultimately, fostering national unity.
So it's not just about listing freedoms, but providing a really detailed framework, including the limitations for how those freedoms actually operate in society. What's the ultimate purpose then, the ideal they're aiming for?
Well, at their core, the fundamental rights are really meant for promoting the ideal of political democracy. They're designed to be a strong check, a constitutional barrier, if you like, preventing the rise of authoritarian or despotic rule. They actively protect the liberties and freedoms of the people against potential overreach or invasion by the state.
Right.
Think of them as operating like built-in limitations on the potential tyranny of the executive branch, and also on the possibility of the legislature passing arbitrary laws.
Putting the rule of law above the arbitrary actions of those in power. That phrase from your source, a government of laws and not of men, seems to capture that perfectly.
It really does. It signifies a system where governance happens according to established legal principles and rights, rather than, the personal whims or unchecked power of the individuals who happen to hold office at the time.
And why give them this special status? Why call them fundamental?
They're called fundamental for a couple of key reasons, really rooted in the Constitution's philosophy. Firstly, they are guaranteed and protected directly by the Constitution itself, which is the highest law, the fundamental law of the land, that gives them a status superior to ordinary laws passed by Parliament. Secondly, and perhaps even more profoundly, they're considered absolutely essential for the all-round development of individuals. This isn't just about politics. It covers the development of a person's material, intellectual, moral, and spiritual potential. The core belief is that without these basic constitutional protections, individuals just cannot truly flourish and realize their full potential as human beings.
Got it. So fundamental because they're constitutionally protected and essential for human development. That lays a really solid foundation for understanding why they matter so much. Now, you mentioned the list. It hasn't stayed exactly the same since 1950, has it?
No, it hasn't.
Yeah.
Originally, when the Constitution came into effect, Part 3 listed 7 categories of fundamental rights.
Okay, let's quickly run through those original 7 categories and their article ranges just to get the picture.
Sure. The original list was, first, the right to equality, that's Articles 14 to 18. Second, the right to freedom, Articles 19 to 22. Third, the right against exploitation, Articles 23 and 24. Fourth, the right to freedom of religion, Articles 25 to 28. Fifth, cultural and educational rights, Articles 29 and 30. Sixth was the right to property, Article 31. And seventh, the right to constitutional remedies, which is Article 32.
Right, and Article 32, the right to constitutional remedies, is obviously pivotal, makes the others enforceable. We'll definitely spend some significant time on that one later. But you mentioned a change. One of these was actually removed.
Yes, the most significant change to the list was the deletion of the right to property from the list of fundamental rights. This was done by the 44th Amendment Act back in 1978.
1978. That was a pretty complex period in Indian politics and constitutionally, especially after the emergency, wasn't it? What really prompted removing the right to property from this core list?
Well, the main reason, as your source details, was the immense legal friction and, frankly, controversy it generated. The right to property, especially Article 31, which dealt with acquisition and requisition, became a major flashpoint. A real conflict between Parliament wanting to enact socioeconomic reforms like land ceiling laws, redistribution, and the judiciary's role in protecting fundamental rights, often focusing on, whether the compensation paid by the state was adequate. This conflict led to numerous constitutional amendments trying to sort of bypass judicial review for property laws. So by removing it from Part 3, Parliament basically aimed to reduce this friction and make it easier to legislate on property matters without the constraint of it being a fundamental right directly enforceable under Article 32.
So it was moved out of Part 3. Where did it go then? Did the right to own property just disappear entirely?
No, it didn't vanish. It was recategorized. Yeah. It's now a legal right, or maybe more accurately, a constitutional right, located under Article 300A, which is in Part 12 of the Constitution. And the text of Article 300A is pretty straightforward. No person shall be deprived of his property, save by authority of law.
Okay, so the state can still acquire property, but it has to be done according to a law. The key difference is it's no longer a fundamental right, which means you lose that direct access to the Supreme Court under Article 32 if it's violated, and the whole compensation guarantee changed too. We'll definitely need to explore the implications of that shift later on.
We will. That dilution left the list with 6 categories of fundamental rights, which is where we are today.
Rights. So the current 6 are right to equality, Articles 14-18, right to freedom, 19-22, right against exploitation, 23-24, right to freedom of religion, 25-28, cultural and educational rights, 29-30, and that vital right to constitutional remedies, Article 32.
Correct. And the nature of these 6 remaining rights, and really the whole fundamental rights framework, it comes with several key characteristics that define how they operate within the Indian legal system.
Let's explore those defining characteristics then. What makes these rights different from just ordinary legal rights?
Okay, firstly, their availability. This is a crucial point right away. Some fundamental rights are exclusively available only to citizens of India. But importantly, many others are guaranteed to all persons. And this broad category includes not just citizens, but also foreigners and even legal entities like corporations or companies.
Ah.
For example, the right to equality under Article 14, or the protection of life and personal liberty under Article 21, they apply to everyone within India's territory. But the freedoms listed in Article 19, like freedom of speech, assembly, or association, those are only for citizens.
That's a really significant distinction. So not every single right listed in Part 3 applies universally to everyone physically present in India.
No, they're selectively available, depends on the specific right and whether you're a citizen or not. Secondly, and this is a very important characteristic, often highlighted in critiques actually, these rights are not absolute, they are qualified. The Constitution itself says the state can impose reasonable restrictions on how these rights are exercised.
Reasonable restrictions. That sounds potentially vague. How is that defined? And who gets to decide if a restriction is actually reasonable?
That power rests with the courts. The determination of whether a restriction imposed by the state on a fundamental right is, in fact, reasonable is subject to judicial review. This is where the courts step in to make sure the restriction isn't arbitrary or excessive. The underlying idea is to strike a necessary balance between the essential rights and liberties of the individual on one side and the interests of the larger society, things like public order, morality, health, or state security, on the other. It's balancing liberty versus social control.
So the state can regulate, but the courts act as a check to ensure that regulation isn't just used to arbitrarily squash rights.
Exactly. Thirdly, while the main job of fundamental rights is to protect individuals against arbitrary action by the state, some of these rights are also enforceable against private individuals.
Oh, okay. It's like.
Article 17, which abolishes untouchability, is a prime example. Its violation by anyone, including private persons, is punishable by law. Article 23, prohibiting forced labor, is another.
That's vital. It means these rights aren't just about limiting government power. Some actually tackle deep-seated societal issues and place obligations on individuals too.
Indeed. Fourthly, the nature of these rights varies. Some are negative in how they're phrased, acting as prohibitions on the state, saying the state shall not do something that would infringe a right. Others are positive, conferring rights or privileges on individuals that the state must actually uphold or facilitate.
Fifth, and this brings us back to Article 32, they are justiciable.
Absolutely. This is their defining feature in terms of enforcement. If a fundamental right is violated by the state, or in some cases by private individuals, the aggrieved person has the right to move the courts directly for its enforcement. This justiciability is what gives these rights their real teeth, their real power and significance.
And the ultimate defender of these rights is the Supreme Court.
Yes, the Supreme Court is designated as the defender and guarantor of the fundamental rights. As we'll discuss when we get to Article 32, an aggrieved person can go directly to the Supreme Court for the enforcement of their fundamental right. This direct access to the highest court really underlines how paramount these rights are considered within the whole constitutional scheme.
Direct access, bypassing lower courts, that is a powerful mechanism.
It truly is. Seventh characteristic. Despite being fundamental, they aren't considered sacrosanct or permanent in an absolute sense. Parliament does have the power to curtail or even repeal them.
But not easily.
No, not through an ordinary law. It requires the much tougher process of a Constitutional Amendment Act, passed under Article 368. And crucially, as established by the Supreme Court in that landmark Kesavananda Bharati case in 1973, this power of amendment is not unlimited. Parliament cannot amend the Constitution, including the fundamental rights, in a way that affects or alters the basic structure of the Constitution.
The basic structure doctrine, a critical judicial check on Parliament's amending power, making sure certain core principles, many tied to fundamental rights, remain untouchable.
Precisely. Eighth, the enjoyment of these rights can be suspended, but only during the operation of a national emergency declared under Article 352. However, even during an emergency, there are absolute protections. The rights guaranteed by Articles 20, protection regarding conviction for offenses, and 21, protection of life and personal liberty, can never be suspended. Furthermore, the 6 freedoms under Article 19. They're automatically suspended only when the national emergency is declared because of war or external aggression. an external emergency, not when it's declared due to armed rebellion, an internal emergency.
So life and personal liberty are sacrosanct, even in a national crisis, and core freedoms like speech are specifically protected during internal disturbances that must be a safeguard added after the 1975 emergency experience.
Those are vital limitations on the state's power, yes, even during emergencies. Ninth, the scope of fundamental rights is also subject to specific constitutional limitations found in Articles 31A, 31B, and 31C. These articles were brought in or modified over time, mainly to protect certain types of laws, especially those related to land reforms, and implementing certain directive principles from being challenged for violating fundamental rights like Articles 14 and 19.
So there are specific constitutional carve-outs that allow certain laws to override or be immune from challenge based on particular fundamental rights, sort of like shields.
Yes, shields reflecting the historical attempts to prioritize socioeconomic reforms. 10th, the application of fundamental rights to members of specific disciplined forces, armed forces, paramilitary forces, police, intelligence agencies, can be restricted or even abrogated by Parliament under Article 33. This is explicitly allowed by the Constitution to ensure they can discharge their duties properly and maintain the strict discipline needed in such forces.
That makes practical sense for organizations where discipline is absolutely paramount.
Indeed. 11th, the application of fundamental rights can also be restricted when martial law is in force in any area. That's Article 34. Martial law essentially means military rule imposed under extraordinary circumstances, like a severe breakdown of law and order, where the military temporarily takes over administration to restore normalcy. This is quite different from a national emergency, and we can look at that comparison later.
Martial law sounds like a very severe measure, temporarily overriding civilian administration and rights.
It is, and Article 34 provides the constitutional basis for restricting fundamental rights in that scenario, and for Parliament to later validate actions taken under martial law. Finally, most fundamental rights are directly enforceable. They're self-executory. You don't need Parliament to pass a separate law to make them effective. However, a few fundamental rights do require Parliament to make specific laws for their enforcement, or to prescribe punishments for their violation, as mentioned in Article 35.
For example,
Parliament must enact laws for punishing acts of untouchability under Article 17, or forced labor under Article 23. Article 35 makes sure that only Parliament has this power to make these specific laws, even if the subject matter might normally fall under the state list, which guarantees uniformity of enforcement across the country.
Okay, a really detailed set of characteristics. Powerful, justiciable rights, but also with built-in limits, exceptions, and specific rules for different groups or situations. Now, before we dive into the specific rights themselves, Article 12 defines a term that's absolutely central to understanding who these rights are protected against: the state. What does the state actually cover in this context?
That's a critical definition for Part 3 because, as we said, most fundamental rights are limitations on the actions of the state. Article 12 provides this definition specifically for Part 3. And the term state is interpreted in a very, very broad and inclusive sense. It includes, first, the government and Parliament of India, so the executive and legislative branches at the central level.
Right.
Second, the government and legislature of each of the states, the executive and legislative organs at the state level. Third, all local authorities. This is a wide category covering statutory bodies at the local level, like municipalities, panchayats, district boards, improvement trusts, basically any legally constituted body exercising governmental functions locally. And fourth, this is the catch-all. All other authorities within the territory of India or under the control of the government of India. This is a broad residual category that the courts have interpreted quite expansively over time. It includes statutory authorities like LIC, ONGC, SAIL, created by specific acts, and sometimes even non-statutory authorities if they exercise significant governmental power or are deeply controlled by the government.
So it's definitely not just the obvious central and state governments. It's also local bodies and a whole range of other entities performing public functions or controlled by the government. That significantly broadens who fundamental rights can be enforced against.
Absolutely. The definition is deliberately wide to make sure individuals are protected against arbitrary actions by pretty much any entity that can be considered an instrument or agency of the state. The Supreme Court has even held that, under certain circumstances, a private body or agency can be deemed an instrumentality of the state if it performs public functions or is under, deep and pervasive state control. And if so, it falls into the definition of state in Article 12. This means the actions of all these diverse entities can be challenged in court if they violate fundamental rights.
That's a key aspect for accountability, making sure entities using state power are subject to the fundamental rights framework. And how do the courts actually check if laws or actions violate these rights? This brings us to Article 13, which deals with laws inconsistent with fundamental rights.
Right. Article 13 is foundational to the whole system of judicial review in India, especially regarding fundamental rights. It explicitly declares that all laws in force in India before the Constitution started, if they are inconsistent with Part 3, shall be void to the extent they are inconsistent.
Okay, pre-existing law.
Yes. And then it goes on to say that the state shall not make any law which takes away or abridges the rights conferred by Part 3, and any law made in contravention of this clause shall be void to the extent of the contravention.
So it essentially puts all laws, old and new, on notice. Don't violate fundamental rights or you'll be struck down. This is the constitutional basis for the Supreme Court, under Article 32, and the High Courts, under Article 226, to use the power of judicial review and declare a law unconstitutional or invalid if it violates a fundamental right.
Exactly. It's the constitutional backbone for the judiciary's role as the guardian of fundamental rights. Now, what exactly counts as law in Article 13? Is it just acts passed by Parliament and state legislatures?
Your source indicates it's interpreted very broadly.
It is. The meaning of law under Article 13 is wide enough to cover various forms of legal rules. It includes, firstly, permanent laws enacted by Parliament or state legislatures. Secondly, temporary laws, like ordinances issued by the president or state governors when legislatures aren't in session. These have the force of law, temporarily at least. Thirdly, statutory instruments, basically delegated legislation. This includes orders, bylaws, rules, regulations, notifications issued by the executive under authority given by primary legislation. And fourthly, even non-legislative sources of law, like custom or usage, but only if they have the force of law in India.
So even a long-standing custom, if it has legal force or a regulation issued by a government department, could potentially be challenged under Article 13 if it violates a fundamental right. That's pretty extensive coverage.
It ensures the protection isn't limited to just formal acts, but extends to various ways the state creates legally binding rules. Now, a major historical question was, are constitutional amendments themselves considered law under Article 13? This was central to the conflict over property rights and Parliament's power to amend fundamental rights. And the Supreme Court's position on this evolved quite a bit. It did, significantly. Initially, in early cases like Shankari Prasad in 51 and Sajjan Singh in 65, the Supreme Court said no. The term law in Article 13 did not include constitutional amendment acts made under Article 368, which meant Parliament could amend fundamental rights without them being challenged under Article 13.
Right.
However, in the Goloknath case in 1967, the court completely changed its mind, holding that a constitutional amendment was a law under Article 13, and therefore Parliament could not take away or abridge fundamental rights. This created a real deadlock, as Parliament felt its hands were tied in implementing its reform agenda.
And this led Parliament to pass the 24th Amendment Act in 1971, explicitly stating that constitutional amendment acts are not laws for the purpose of Article 13.
Yes, basically trying to legislatively override the Goloknath ruling. This all set the stage for the monumental Kesavananda Bharathi case in 1973. In this case, the Supreme Court upheld the 24th Amendment, confirming that Parliament does have the power to amend any part of the Constitution, including fundamental rights. However, it simultaneously introduced the basic structure doctrine.
Ah, the famous doctrine.
Exactly. Ruling that while Parliament can amend fundamental rights, it cannot do so in a way that alters or damages the basic structure or fundamental framework of the Constitution.
So while a constitutional amendment isn't a law subject to the full constraints of Article 13's voiding power in the original sense, it is subject to judicial review if it infringes on a fundamental right that forms part of this basic structure. That was a truly revolutionary judgment, wasn't it?
It was a brilliant judicial balancing act. It acknowledged Parliament's power to amend, but preserved the core identity of the Constitution, with the judiciary positioned as the final judge of what constitutes that basic structure. This whole framework, flowing from Article 13 and judicial interpretation, underpins the check on state power.
That provides the crucial backdrop for how laws are tested against these rights. Let's move now into the specific rights themselves, starting with the first big category. The right to equality, covered in Articles 14 through 18. This is often seen as the absolute bedrock of a democratic and just society.
Absolutely. Equality is foundational. Article 14 lays down the general rule. It says, "The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India."
Any person, so this right to equality applies very broadly, not just to citizens.
Correct. Article 14 applies to all persons, citizens, foreigners, and even legal entities like statutory corporations, companies, etc. The article uses two distinct phrases which, although aiming for the same goal of equality, has slightly different origins and meanings.
Okay, tell us about the difference between equality before the law and equal protection of the laws.
Equality before the law is a concept that comes mainly from British common law, associated strongly with A.V. Dicey's idea of the rule of law. It's often seen as a more negative concept because it emphasizes the absence of any special privileges for anyone. It means everyone, regardless of status, wealth, or position, rich or poor, high or low, official or non-official, is equally subject to the ordinary law of the land and answerable to the ordinary law courts. Nobody is above the law.
So everyone stands equal in the eyes of the law and the courts. Simple enough.
Pretty much. Equal protection of the laws, on the other hand, is a concept borrowed from the American Constitution. It's seen as a more positive concept. It means that the law should be applied equally among those who are similarly situated or in similar circumstances. It implies equality of treatment under equal circumstances, like should be treated alike without discrimination. But importantly, it doesn't require that unequal individuals must be treated equally.
Okay, so equality before the law is about everyone being subject to the same system, while equal protection is more about treating similarly situated people the same way. They sound complementary.
They are. Both phrases together aim to establish equality of legal status, opportunity, and justice. Now, the Supreme Court has clarified that Article 14 does not forbid reasonable classification. It recognizes that in a diverse society, treating everyone identically, ignoring their actual differences or circumstances, might not actually lead to substantive equality.
Reasonable classification, how is that different from discrimination then?
Well, classification is permitted, but it must be based on an intelligible differential, a real discernible difference between the groups being classified, and this classification must have a rational nexus or a substantial distinction that relates to the objective the law is trying to achieve.
For example?
A law might classify industries based on size for tax purposes, or individuals based on income for progressive taxation. As long as the classification isn't arbitrary, artificial, or just designed to get around the principle of equality, and it serves a legitimate state purpose, it's generally okay. Article 14 is really about striking down arbitrary classification.
So difference in treatment is allowed, but only if there's a logical, non-arbitrary reason tied directly to the law's purpose. You mentioned Dicey's rule of law earlier in relation to equality before the law. Can you elaborate on that connection?
Yes, the equality before law part of Article 14 is a direct reflection of Dicey's second element of the rule of law. Dicey outlined three main elements. First, the absence of arbitrary power government can't punish anyone except for a clear breach of law established in the ordinary way.
Right.
Second, equality before the law, everyone, including officials, is subject to the same ordinary law and tried by the ordinary courts. Your source quotes Dicey here, emphasizing, "No man is above the law. Every official from the prime minister down to a constable is under the same responsibility for every act done without legal justification as any other citizen." This element is fully applicable in India.
Okay.
The third element Dicey mentioned was the primacy of individual rights, suggesting the Constitution resulted from rights defined by courts. This element doesn't quite fit India, where the Constitution is the source of individual rights.
So while the Constitution is the source of rights in India, that core idea of everyone, including those in power, being equally subject to the law is directly from Dicey's rule of law.
Exactly. And reinforcing its importance, the Supreme Court has declared that the rule of law as embodied in Article 14 is a basic feature of the Constitution, which means it's part of that core unamendable structure from the Kesavananda Bharati case. Parliament cannot amend the Constitution in a way that destroys the rule of law principle under Article 14.
That gives Article 14 pretty significant protection against being weakened through constitutional amendment. Now, despite this fundamental principle, the source material lists several exceptions to this rule of equality before law. What are these important carve-outs?
Yes, the principle isn't absolute, and the Constitution itself provides certain exceptions, usually based on the nature of an office or role. First, the President of India and the governors of states enjoy significant immunities under Article 361. They aren't answerable to any court for exercising their official powers and duties. No criminal proceedings can be started or continued against them during their term. No arrest or imprisonment process can be issued during their term. And even civil proceedings against them personally require 2 months' notice.
Wow, quite extensive legal protection while they're in office, designed to let them function without constant threat of lawsuits, I suppose.
That's the rationale, yes. Second, under Article 361A, no one is liable for publishing a substantially true report of Parliament or state legislature proceedings in newspapers, radio, or TV
Immunity
for reporting. Third, members of Parliament have immunity under Article 105 for anything said or any vote given in Parliament or its committees. Fourth, similarly, members of state legislatures have immunity under Article 194 for anything said or any vote given in the state legislature or its committees.
These immunities for legislators seem clearly aimed at ensuring free and fearless debate within those bodies without worrying about legal repercussions for their speech or votes.
Exactly. It's considered essential for parliamentary democracy. Fifth, Article 31C, which we'll discuss more later, acts as an exception. Laws made to implement certain directive principles in Article 39B or C cannot be challenged for violating Article 14 or Article 19. The Supreme Court famously said, where Article 31C comes in, Article 14 goes out for these specific laws.
So certain laws aimed at specific socioeconomic goals are shielded from challenge based on equality or certain freedoms.
Yes. Additionally, international law provides immunity from criminal and civil proceedings for foreign sovereigns, ambassadors, and diplomats. The UN and its agencies also enjoy diplomatic immunity. So while Article 14 establishes a strong principle, these specific constitutional and international law exceptions do exist.
Okay. Moving on from the general principle of equality in Article 14, Article 15 prohibits discrimination on specific grounds.
Article 15 is a more focused application of the equality principle. It specifically prohibits the state from discriminating against any citizen on grounds only of religion, race, caste, sex, or place of birth.
The word only is doing a lot of work there, isn't it?
It's crucial. It means discrimination on other grounds isn't prohibited by Article 15 itself. For example, discrimination based on residence might be okay in some situations, as we'll see under Article 16. Now, Article 15 doesn't stop there. It has a second, equally important part. No citizen shall be subjected to any disability, liability, restriction, or condition on grounds only of religion, race, caste, sex, or place of birth, regarding firstly access to shops, public restaurants, hotels, and places of public entertainment, or secondly, the use of wells, tanks, bathing ghats, roads, and places of public resort that are maintained wholly or partly by the state or dedicated to the use of the general public.
This second part seems to go beyond just state action.
Yes, and that's a vital point. While the first provision of Article 15 targets discrimination by the state, this second provision prohibits discrimination on these grounds not only by the state but also by private individuals concerning access to these specific public places and amenities.
Ensuring access to public spaces and resources isn't denied based on these fundamental identity markers. Now, just like Article 14, are there exceptions to this non-discrimination rule in Article 15, especially regarding things like affirmative action or reservations?
Yes, and this is where we see the constitutional basis for reservation policies evolving significantly over time. Article 15 includes 4 important exceptions. First, the state is permitted to make any special provision for women and children. This allows for positive discrimination or affirmative action for them, like reserving seats in local bodies or providing free education for children, Article 15.3.
Okay.
Second, the state can make special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. This exception to Article 15.4, added by the First Amendment in 1951, provides the basis for reservations or fee concessions for these groups in public educational institutions.
Added right near the beginning, reflecting an immediate need to address historical disadvantages.
Indeed. Third, a major expansion came with the 93rd Amendment Act of 2005, adding Article 15.5. This empowered the state to make special provision for the advancement of socially and educationally backward classes, or SCSSTs, regarding their admission to educational institutions, including private ones, whether aided or unaided. The only exception is minority educational institutions under Article 31.
Wow, so extending reservations into the private education sector, acknowledging its growing role, but still respecting the special status of minority-run institutions.
Exactly. And the most recent exception was added by the 103rd Amendment Act of 2019, introducing Article 15.6. Fourth, this allows the state to make special provision for the advancement of economically weaker sections, EWSs of citizens. It also permits the state to provide for reservation of up to 10% of seats for EWSs in admission to educational institutions, including private ones, aided or unaided, again, except minority institutions. And this 10% EWS reservation is specifically stated to be in addition to the existing reservations for SEs, STs, and OBCs.
A totally distinct category based purely on economic criteria, separate from the social and educational backwardness criteria used for SCS TOBC.
Yes. The criteria for defining these EWS are to be notified by the state, based on family income and other indicators of economic disadvantage.
Let's dive a bit deeper into how these reservation clauses have been implemented, particularly for OBCs in education and the EWS criteria, as your source gives specifics. The exception in 15.5 for OBCs in education that was put into action by a specific law, wasn't it?
Yes, the Central Educational Institutions Reservation and Admission Act 2006 was passed by Parliament to implement Article 15.5 for central government educational institutions. It provides for that 27% quota for OBCs in central higher education institutions, including places like the IITs and IMs.
And the Supreme Court reviewed this act.
It did. In April 2008, the court upheld the constitutional validity of both the 93rd Amendment, Article 15.5, and the 2006 Act itself. However, echoing principles from the Mandel case regarding OBC job reservations, the court directed the central government to exclude the creamy layer among the OBCs when implementing this 27% quota.
The creamy layer, right, the economically and socially advanced sections within the OBC category, the idea being to ensure the reservation benefits actually reach the most disadvantaged within that group.
Precisely. Your source details the categories of people whose children are considered part of the creamy layer and are thus excluded from this OBC quota benefit. It's quite specific, includes individuals holding constitutional posts, people in certain ranks of government services, Group AB officers in central state services, PSUs, banks, universities, equivalent private jobs, higher ranks in the armed forces, colonel and above, professionals like doctors, lawyers, people in trade business industry, those holding agricultural land above a limit or certain urban property, and, crucially, individuals with a gross annual family income exceeding a specified threshold.
That's a pretty comprehensive list of exclusions, trying to target the benefits effectively. And that income threshold for the creamy layer, it's been adjusted over time.
Yes, it's been periodically revised. Started at 1 lakh in 1993, went up to 2.5 lakh in 2004, 4.5 lakh in 2008, Eureth lakh in 2013, and the figure mentioned in the source, as of 2017, is 8 lakh per annum.
Reflecting the changing economic landscape, what about the EWS reservation in educational institutions under the new Article 15.6? What are the eligibility criteria there?
Article 15.6, added by the 103rd Amendment in 2019, allows for that 10% reservation for economically weaker sections who aren't covered by the existing SCST-OBC reservations. The central government issued an order in 2019 laying out the criteria, which are quite detailed. The main criterion is family gross annual income being below 8 lakh in a financial year before application. This income includes everything: salary, agriculture, business, profession, etc.
So a clear income cutoff, but there are also asset-based exclusions mentioned.
Yes, even if the family income is below 8 lakh, they are excluded from EWS eligibility if the family owns any of the following assets: 5 acres or more of agricultural land, a residential flat of 1,000 square feet or more, a residential plot of 100 square yards or more in notified municipalities, or a residential plot of 200 square yards or more outside notified municipalities.
So holding significant agricultural land or urban property disqualifies you, regardless of your current income level.
Correct. The rules also specify that property owned by different family members in different places must be clubbed together for these asset tests. And family for EWS eligibility is defined specifically: the applicant, their parents, siblings under 18, and their spouse and children under 18.
Those are very specific criteria to define the EWS category and target the benefit. Okay, moving from education to employment, Article 16 deals with equality of opportunity in public employment.
Article 16 is another specific application of the equality principle, this time guaranteeing equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It reinforces non-discrimination, stating no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, or residence, be ineligible for or discriminated against in respect of any state employment.
So adding descent and residence to the prohibited grounds for discrimination in public jobs compared to Article 15. But again, like Article 15, there must be exceptions carved out for this principle of equal opportunity in state employment.
Yes, Article 16 also contains several important exceptions allowing deviations. First, Parliament can make a law prescribing residence as a condition for certain state or local government jobs, Article 16(3). Though, as your source notes, this power is currently used very restrictively, mainly for Andhra Pradesh and Telangana via Article 371D. Second, the state can reserve appointments or posts for any backward class of citizens, which, in the state's opinion, isn't adequately represented in state services, Article 16(4). This is the main basis for SC/ST/OBC job reservations. Third, a major addition was Article 16(4)(a), brought in by the 77th Amendment in 1995. This empowered the state to provide for reservation and promotions for SCs and STs if they aren't adequately represented. And the 85th Amendment in 2001 added that this promotion reservation could include consequential seniority, applied retrospectively from 1995.
Right, so a reservation wasn't just for getting into government service. It could also apply to moving up the ranks, and those promoted via reservation would gain seniority as a result. That must have been contentious.
It was, and remains so. Fourth, another crucial amendment was the 81st in 2000, adding Article 16(4)(b). This lets the state treat unfilled reserve vacancies from 1 year as a separate class to be filled in later years. Importantly, these backlog vacancies are not counted towards the 50% reservation ceiling in the year they are filled. This effectively ended the 50% ceiling specifically for backlog vacancies.
That's a significant mechanism, allowing the state to fill past reserved posts, even if it pushes total reservations in a given year beyond 50%.
It is. Fifth, a law can provide that the holder of an office related to a religious or denominational institution must belong to that specific religion or denomination, Article 16(5). So religious criteria are allowed for jobs within religious institutions. Sixth, mirroring Article 15(6), the 103rd Amendment in 2019 added Article 16(6). This permits the state to provide for reservation of up to 10% of appointments or posts for economically weaker sections, EWSs. Again, this 10% is additional to existing reservations, and the EWS criteria are the same income and asset tests used for Article 15(6).
So EWS reservation applies to both education and public employment. Your source also mentions the possibility of exempting certain scientific or technical posts from this EWS reservation under Article 16(6).
Yes. The central government order implementing the EWS quota allows for exempting certain scientific and technical posts. This applies to higher grade posts, above lowest group A, classified as scientific or technical needing specific science tech knowledge, and are meant for research roles.
Interesting. Seems like an attempt to balance reservation policy with the need for highly specialized expertise in specific government research areas.
Precisely. Now, to really grasp the evolution and impact of reservations under Article 16, especially for OBCs, we absolutely have to look at the historical context of the Mandel Commission and everything that followed. It's a crucial part of your source material.
This was a major political and legal flashpoint, wasn't it? Tell us about the Mandel Commission itself.
The Second Backward Classes Commission, chaired by B.P. Mandel, was appointed in 1979 under Article 340 of the Constitution. Its job was to investigate the conditions of socially and educationally backward classes in India. There was a first commission back in 1953 under Kaka Kalelkar. The Mandel Commission submitted its report in 1980. It identified, I think, 300 and 743 castes as socially and educationally backward, estimating they made up about 52% of the population, excluding SCs and STs.
And its key recommendation was?
Its main recommendation was for a 27% reservation of government jobs for these other backward classes OBCs. This 27% would be on top of the existing reservations for SCs and STs, bringing the total reservation quota to around 50%.
The recommendation came in 1980, but the implementation was much later, causing quite a stir.
Yes, it wasn't until 1990 that the VP Singh government announced it would implement the 27% reservation for OBCs in central government jobs. The next government, under Narasimha Rao in 1991, made a couple of tweaks. Introduced a preference for the poorer sections within that 27% OBC quota, an economic criterion, and also proposed a separate 10% reservation for other economically backward sections not covered by existing schemes.
And these government decisions led to widespread protests and eventually the landmark Indrasani case in 1992, often just called the Mandel case.
Yes, this was absolutely pivotal for reservation policy. The Supreme Court, in this case, really dug into the scope and limits of Article 16(4). The court delivered a complex verdict. It struck down the Narasimha Rao government's proposal for a separate 10% reservation for other economically backward sections, saying Article 16(4) is only for backward classes who aren't adequately represented, implying it required more than just economic backwardness at that time.
But it upheld the 27% reservation for OBCs.
Yes, the court upheld the constitutional validity of the 27% reservation for OBCs. but it laid down some really crucial conditions for how it should be implemented. These included: first, the creamy layer among the OBCs must be excluded from the reservation benefit.
Right.
Second, there should be no reservation in promotions. Reservations should be confined to initial appointments only. The court said existing promotion reservations would only be valid for 5 years, until 1997. Third, the total reserve quota should not exceed 50%, except maybe in extraordinary situations, and this 50% rule should apply annually. Fourth, the carry-forward rule for unfilled backlog vacancies was held valid, but with the condition that the total reservation in any given year must not breach the 50% limit. Fifth, a permanent statutory body should be set up to examine complaints about including or excluding castes from the OBC list. And sixth, regarding promotion reservations, which they had initially limited, there should be no relaxation in qualifying marks or evaluation standards, citing the need to maintain administrative efficiency under Article 335.
Those rulings were significant judicial checks, excluding the creamy layer, banning promotion reservations, sticking strictly to the 50% ceiling. How did the government and parliament react to these conditions?
Well, the response was a mix of implementing some directives and using constitutional amendments to override others. To implement the creamy layer exclusion, the government appointed the Ram Nandan Committee in 1993, and its report identifying the creamy layer was accepted.
Okay.
The National Commission for Backward Classes was set up by an act in 1993, later given constitutional status by the 102nd Amendment in 2018, adding Article 338B, fulfilling that requirement for a permanent body. But then, to nullify the ruling against reservation and promotions, Parliament passed the 77th Amendment in 1995, adding Article 16(4)(a), specifically empowering the state for promotion reservation for SC/SCs. Then, the 85th Amendment in 2001 added the consequential seniority aspect, retrospectively from 1995.
So directly countering the court's ruling on promotions.
Directly. And to nullify the ruling, the backlog vacancies count towards the 50% ceiling. Parliament passed the 81st Amendment in 2000, adding Article 16(4)(b), allowing unfilled reserve vacancies to be a separate class, effectively removing the 50% ceiling on those backlog vacancies. To protect the Tamil Nadu Reservations Act of 1993, which had 69% reservation, the 76th Amendment in 1994 placed it in the 9th schedule, aiming to shield it from judicial review based on the 50% rule. And finally, to nullify the ruling against relaxing standards and promotion reservations for SC/STs, Parliament passed the 82nd Amendment in 2000, adding a proviso to Article 335, explicitly permitting relaxation or lowering of standards for SC/STs in promotion reservations.
Wow. That historical sequence really illustrates the dynamic, sometimes tense relationship between Parliament's legislative power, often driven by policy goals and political factors, and the judiciary's role in interpreting the Constitution and fundamental rights. Parliament clearly used its amending power quite extensively to counter specific parts of the Mandel case verdict, all while operating under the larger constraint of the basic structure doctrine.
It's a compelling example of the Constitution as a living document, constantly shaped by this interplay. And most recently, as we mentioned, the 103rd Amendment in 2019 added Article 16(6) for the 10% EWS reservation in public employment, with the central government order following in 2019 providing implementation details, including eligibility and that exemption for certain scientific posts.
A complex and clearly still evolving landscape under equality and equal opportunity.
Okay, moving on, Article 17 deals with the hugely important issue of abolishing untouchability.
Article 17 is one of the most direct and impactful articles in Part 3, tackling a deeply ingrained historical social injustice. It explicitly abolishes untouchability in all its forms and forbids its practice. It clearly states that enforcing any disability arising from untouchability is an offense punishable by law.
And this is another right that protects against both the state and private individuals, isn't it?
Yes, that's key. Like Article 15(2), in certain contexts, Article 17 is available to everyone, citizens and non-citizens, and protects them against actions by the state and by private persons. To enforce Article 17, Parliament enacted the Untouchability Offences Act back in 1955. This act was later amended and renamed the Protection of Civil Rights Act in 1976, broadening its scope and making penalties tougher.
The term untouchability itself isn't actually defined in the Constitution or the Act, though, is it?
No, it's not explicitly defined, but courts have interpreted it in its historical context. The Mysore High Court held that the term should be understood to refer to the practice as it had developed historically in India, resulting in social disabilities imposed on certain classes purely because of their birth in certain castes. It doesn't cover, say, a purely social boycott of an individual for non-caste reasons. The Supreme Court, in the People's Union for Democratic Rights case in 1982, also affirmed that the right against untouchability under Article 17 is available against private individuals, and importantly, the state has a constitutional obligation to take necessary action to ensure this right is not violated by anyone.
So the state isn't just forbidden from practicing it, but has a positive duty to prevent its practice by anyone. Got it. Article 18, the last one in this section, deals with abolishing titles.
Article 18 is designed to prevent the creation of artificial hierarchies based on titles, which were common before independence. It makes 4 specific points. First, it prohibits the state from conferring any title on anyone, citizen or foreigner, except for military or academic distinctions.
Okay, so military ranks and academic degrees are fine.
Yes. Second, it prohibits an Indian citizen from accepting any title from any foreign state. Third, a foreigner holding any office of profit or trust under the Indian state cannot accept any title from a foreign state without the president's consent. Fourth, no person, citizen or foreigner, holding an office of profit or trust under the state can accept any present, emolument, or office from a foreign state without the president's consent.
This was clearly aimed at ending that whole system of hereditary titles of nobility like Maharaja, Rajabahadur, Rai Bahadur, and so on, which were seen as going against the principle of equality of status.
Exactly. It promotes a more egalitarian society by stopping the formal recognition of status through such titles. However, a question came up regarding national awards like Bharat-Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri. In the Balaji Raghavan case in 1995, the Supreme Court looked at whether these national awards counted as titles under Article 18.
And what did the court decide?
The Supreme Court upheld the constitutional validity of these national awards. It ruled that these awards do not amount to titles in the sense prohibited by Article 18. The court reasoned that Article 18 only prohibits hereditary titles of nobility, and those creating artificial distinctions based on birth or rank. National awards, the court said, are simply recognitions of exceptional service or merit in various fields and don't violate equality, because equality doesn't mean merit shouldn't be recognized.
But they shouldn't be used in a way that effectively turns them into titles.
Precisely. The court directed that these national awards should not be used as suffixes or prefixes to the names of awardees. If they are used like that, the awardee should forfeit the award. Your source mentions these awards started in 1954, were stopped briefly in 1977, and revived in 1980. The Padma Awards are usually announced on Republic Day, with limits on the number given each year, generally under 120 Padma Awards, and a max of 3 Bharat-Ratnas per year.
So recognizing merit is okay, even encouraged, but not the creation or use of formal titles that imply some kind of inherent higher status. Okay, that wraps up our look at the right to equality. Next up, a set of crucial individual freedoms guaranteed under the right to freedom, Articles 19 through 22.
Right. Article 19 is absolutely central to civil liberties in India. It originally guaranteed 7 rights, but as we discussed, the right to acquire, hold, and dispose of property, Article 19.1, was deleted by the 44th Amendment in 1978. So it now protects 6 fundamental freedoms specifically for citizens.
And these 6 rights are available only to citizens. That's important.
Yes, that's a key point. Article 19 applies exclusively to citizens of India. Foreigners or legal persons like companies can't claim these rights directly, although the rights of citizen shareholders might sometimes be relevant for companies. Furthermore, these rights are protected only against state action, not against the actions of private individuals.
And like most fundamental rights we've seen, they aren't absolute. They're subject to restrictions.
Correct. The state can impose reasonable restrictions on the exercise of these 6 rights. But, importantly, these restrictions can only be imposed on the specific grounds explicitly listed in Article 19 itself, in clauses 2 through 6. A restriction can't be justified on grounds not mentioned in the relevant clause of Article 19.
So the grounds for restricting each of these 6 freedoms are constitutionally specified and limited. Let's go through them one by one. First, the right to freedom of speech and expression under Article 1930.
This guarantees every citizen the right to express their views, opinions, beliefs, and convictions freely, not just by speaking, but also by writing, printing, picturing, or any other way. It's really a cornerstone of democratic society, allowing for the free flow of ideas. And the Supreme Court has interpreted this right very, very broadly over the years.
Yeah, your source lists numerous aspects the Supreme Court has included under this umbrella. It's clearly much more than just verbal speech.
Oh, much more. Judicial interpretation has brought things like freedom of the press, freedom of commercial advertisements, the right against phone tapping, the right to telecast and broadcast, saying the government doesn't have a monopoly on electronic media, the right against a bund called by a political party, the right to know about government activities, transparency, freedom of silence, the right not to speak, the right against pre-censorship of publications, and the right to demonstration or picketing, but notably not the right to strike.
That distinction between demonstration and strike keeps coming up.
It's important legally. The list keeps expanding too, with societal changes. It includes the right to fly the national flag freely, the right of voters to know about candidates' backgrounds, the right to choose the medium of primary education within limits, the right to express one's gender identity, the right to reply to criticism, the right to post info and videos online, filmmakers' right to exhibit films, and quite recently, the right to access the internet.
The right to access the internet as part of freedom of speech. That's a fascinating, very modern interpretation.
Yes. In the Anuradha Bhasin case in 2020, the Supreme Court acknowledged how vital the internet is for free expression. It held that restrictions on internet access must be reasonable and proportional under Article 19.2. They also link the right to practice one's profession or trade over the internet to Article 19.1g.
Okay. So given this incredibly broad scope, what are the constitutionally permitted grounds on which the state can impose reasonable restrictions on freedom of speech and expression?
Article 19.2 lists the exhaustive grounds. There are 8. Sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Any restriction imposed by law must fall under one or more of these categories and must also be deemed reasonable by the courts.
So a very wide freedom, but subject to specific legally reviewable limitations aimed at protecting the state and society. Okay. Second freedom. The right to assemble peaceably and without arms under Article 19b.
This right allows citizens to hold public meetings, demonstrations, and processions. It's fundamental for collective expression and participation in democracy, but it must be exercised peaceably, without any weapons, and generally on public land.
What does it not protect?
It doesn't protect assemblies that are violent, disorderly, riotous, or involve arms. It also, again, does not protect the right to strike.
And the grounds for restricting this freedom of assembly?
Article 19.3 permits reasonable restrictions on just 2 grounds: sovereignty and integrity of India, and public order. Public order here includes maintaining traffic order in public places. Your source mentions relevant laws like Section 144 of the Criminal Procedure Code, which lets magistrates prohibit assemblies to prevent obstruction, danger, or disturbance, and Section 141 of the Indian Penal Code, defining an unlawful assembly, 5+ people with certain illegal objects, like resisting the law or committing mischief by force.
So the right to gather for protest or discussion exists, but maintaining national security and public peace are valid grounds for regulation. Third freedom. The right to form associations or unions or cooperative societies, Article 19.1c.
This right covers forming political parties, companies, societies, clubs, trade unions, and any other group. The right to form cooperative societies was specifically added by the 97th Amendment in 2011. This includes the right to start an association and keep it going, and it also covers the negative right, the right not to form or join an association.
What are the grounds for restricting freedom of association?
Article 19.4 allows reasonable restrictions on 3 grounds: sovereignty and integrity of India, public order, and morality. Citizens can form associations for lawful objectives. However, the Supreme Court has clarified that the right to get an association recognized by the authorities is not a fundamental right under Article 19. Also, while trade unions have the right to form, the SC has held they don't have a guaranteed right to effective bargaining, or the right to strike, or the right to a lockout. The right to strike particularly is controlled by specific industrial laws, not protected as a fundamental right here.
So forming the group is protected, but the actions and official recognition of that group might be subject to other laws and aren't necessarily fundamental rights themselves.
Interesting. Fourth, freedom. The right to move freely throughout the territory of India, Article 19.1.
This gives every citizen the right to move freely from one state to another or from place to place within a state. As your source notes, the purpose is to promote national feeling, integration, counter parochialism, emphasize India as one unit.
And the grounds for restricting this internal movement. Article 19.5 allows reasonable restrictions on 2 grounds: the interests of the general public and the protection of the interests of any scheduled tribe.
Ah, protection of scheduled tribes again.
Yes, restrictions in tribal areas are allowed to safeguard their distinctive culture, language, customs, traditional ways of life, and property from outside exploitation. The Supreme Court has also upheld restrictions on movement for certain individuals, like prostitutes on public health morals grounds, or people with AIDS, upheld by Bombay HC, in the interest of the general public.
It's interesting how the general public interest and specific protections for scheduled tribes act as limitations here.
It reflects that balancing act, individual liberty versus collective well-being, and protecting vulnerable groups. Your source also points out that freedom of movement has two dimensions: internal, within India, protected by Article 19, and external, going abroad, coming back, which falls under the broader Article 21, right to life and personal liberty. So Article 19 only covers moving within India.
Good distinction. Fifth freedom, closely related to movement. The right to reside and settle in any part of the territory of India, Article 19(1).
This right has two parts: the right to reside, stay temporarily anywhere, and the right to settle, make anywhere your permanent home. Like freedom of movement, this aims to remove internal barriers, promote nationalism, and avoid narrow-mindedness.
Are the grounds for restricting this right similar to freedom of movement?
Yes, Article 19(5) applies here too, allowing reasonable restrictions on the same two grounds: the interests of the general public and the protection of the interests of any scheduled tribe. Again, restrictions in tribal areas are for the same reasons, protecting their culture, customs, property, etc. The source notes tribals often regulate property rights through customary rules, and restricting outsider settling helps preserve this. The SCC has also allowed banning certain people, prostitutes, habitual offenders, from residing in certain areas for public order reasons. This right clearly overlaps and complements freedom of movement.
Okay, these two together ensure citizens can, in principle, move and live anywhere in the country, subject to necessary safeguards for public interest and specific communities. Finally, the sixth freedom under Article 19, the right to practice any profession or to carry on any occupation, trade, or business under Article 19(1).
This is a very broad right, guaranteeing citizens the freedom to choose and pursue any means of livelihood. It's essential for individual economic autonomy and the nation's overall economy.
And what are the grounds for restricting this wide-ranging freedom?
Article 19(6) permits reasonable restrictions in the interest of the general public. It also specifically empowers the state to do two things. First, prescribe the professional or technical qualifications needed for any profession, occupation, trade, or business, like requiring degrees for doctors or licenses for lawyers.
Right.
Second, the state can carry on any trade, business, industry, or service itself, either completely excluding citizens or competing with them. The state doesn't need to justify creating a monopoly in its favor.
So the state can set standards for professions and also run its own businesses, even as a monopoly.
Yes. It's important to note, though, that this right does not include the right to carry on a profession or business that's considered immoral, like human trafficking, or dangerous, like dealing in harmful drugs or explosives. The state can absolutely prohibit such activities or regulate them very strictly through licensing.
So immoral or dangerous livelihoods aren't shielded by this freedom. And you mentioned earlier the Anuradha Bhasin case linked internet access to this right, too.
Yes, the Supreme Court held in that case that the freedom to practice a profession or trade over the internet enjoys constitutional protection under Article 19(1). It reiterated that any restrictions must be reasonable, meet the test of proportionality, and stick to the grounds in Article 19(6). Indefinite suspension of internet services was found impermissible under the temporary suspension rules.
So both freedom of speech and freedom of profession extend into the digital world, but are still subject to that constitutional framework of reasonable restrictions. Okay, that covers the broad freedoms under Article 19. Next, Article 20 provides some really important protections against arbitrary punishment for people accused of crimes.
Article 20 is crucial for protecting individuals against arbitrary and excessive punishment. These protections apply to any person, citizen, foreigner, or even a legal person like a company. It contains three specific safeguards. First, no ex post facto law. This means no one can be convicted for an act that wasn't illegal at the time they committed it, nor can they be given a penalty greater than what was allowed by the law at the time of the offense.
So you can't be punished for something that wasn't a crime when you did it, and you can't get a harsher sentence than what the law prescribed back then.
Exactly. This protection applies only to criminal laws, not civil or tax laws, which can sometimes be retrospective. It prohibits conviction and sentencing under such a retrospective criminal law, but doesn't prohibit the trial itself. It also doesn't apply to preventive detention or demanding security. Second, no double jeopardy. This guarantees that no person shall be prosecuted and punished for the same offense more than once.
Can't be tried and convicted twice for the identical crime.
Correct. This protection applies only in proceedings before a court of law or a judicial tribunal. It doesn't cover departmental or administrative proceedings. So a government employee could potentially be punished departmentally and face criminal prosecution for the same act. Third, no self-incrimination. This provision states that no person accused of any offense shall be compelled to be a witness against themselves.
Often called the right against self-incrimination or the right to remain silent.
Yes. This protection covers both oral testimony and documentary evidence. However, the Supreme Court has clarified its scope. It does not extend to compelling an accused person to produce material objects or to give thumb impressions, specimen signatures, or blood samples. It also doesn't prevent requiring someone to exhibit their body for identification. This protection is available only in criminal proceedings, not civil or other non-criminal cases.
Those distinctions are important. It protects you from being forced to testify or provide documents that incriminate you, but doesn't stop the collection of physical evidence or identification procedures.
Precisely. These three provisions in Article 20 are fundamental safeguards for anyone accused of an offense, embodying principles of fairness in criminal law.
Now, we come to Article 21, Protection of Life and Personal Liberty. This article, as your source really emphasizes, has seen an incredible expansion in its interpretation over the decades. It's now one of the most powerful and wide-ranging rights in the whole Constitution.
Article 21 states, quite simply, no person shall be deprived of his life or personal liberty except according to procedure established by law. Like Articles 14 and 20, this right applies to both citizens and non-citizens. But the simplicity of the text really hides the immense depth of its judicial interpretation.
That phrase, procedure established by law, was the key to its initial, much narrower interpretation, wasn't it?
Yes. In the early years, particularly in the Gopalan case of 1950, the Supreme Court took a very literal, narrow view. It held that Article 21 protection was mainly against arbitrary executive action, but not against arbitrary legislative action. It interpreted procedure established by law strictly to mean just any procedure laid down by a law passed by the legislature.
Yeah.
If a law existed that prescribed a procedure for taking away life or liberty, that was enough, regardless of whether that law or procedure was fair, just, or reasonable. Personal liberty was also given a restricted meaning, basically confined to freedom from physical restraint.
So under that early view, Parliament could theoretically pass a harsh or unfair law that set out some procedure to deprive someone of life or liberty. And the courts couldn't strike it down under Article 21 because, well, a procedure established by law was technically followed.
That was the implication, yes, and it was criticized for not including the due process of law principle found in the U.S. Constitution, which demands the law itself and the procedure must be fair and reasonable. However, this narrow view was dramatically overturned in the landmark Maneka Gandhi case in 1978.
Right. This case completely changed the landscape of Article 21.
It was a watershed moment. The Supreme Court effectively overruled Gopalan and adopted a much wider interpretation. The court held that Article 21 protects against arbitrary executive and legislative action. More importantly, it ruled that the procedure established by law must itself be reasonable, fair, and just. It must conform to principles of natural justice. Any law or procedure that is arbitrary, oppressive, or unfair would be unconstitutional under Article 21.
That sounds very much like introducing the due process of law concept into Article 21, even without using those exact words.
It's widely seen as having done just that, incorporating the substance of due process. Furthermore, the court vastly expanded the meaning of right to life. It held it's not just about mere physical survival, but includes the right to live a life with human dignity, and encompasses all those aspects that make life meaningful, complete, and worth living. Personal liberty was also interpreted in its widest possible scope, covering a huge range of rights constituting personal freedom.
And this expansive interpretation has allowed the Supreme Court over the years since Maneka Gandhi to read numerous other rights into Article 21, seeing them as essential parts of a life with dignity or personal liberty. Your source provides an incredibly long list of these judicially recognized rights.
It's quite a testament to dynamic judicial interpretation. Some of the rights the SC has declared part of Article 21 include the right to live with human dignity itself, the right to a decent environment, pollution-free water air, protection from hazardous industries. The reasoning was a polluted environment impacts quality of life.
Makes sense.
The right to livelihood, losing your livelihood can strip life of dignity. The right to privacy, explicitly affirmed as intrinsic to life and liberty in the Puttaswamy case in 2017. The right to shelter, health, free education up to 14 years before Article 21A. The right to free legal aid for the poor in criminal cases, the right against solitary confinement, the right to a speedy trial, the right against handcuffing, against inhuman treatment, The right against delayed execution, the right to travel abroad, a big one from the Satwant Singh Sawhney case, the right against bonded labor, linking it to dignified life, the right against custodial harassment, the right to emergency medical aid, doctor's assistance, timely treatment in government hospitals.
Wow, the list goes on.
It does. The right not to be driven out of a state, fair trial, prisoners' right to necessities of life, women's right to be treated with decency, dignity, right against public hanging, right to a road in hilly areas, right to information, right to reputation, right of appeal from conviction, right to family pension, social economic justice empowerment, right against bar fetters on prisoners, right to life insurance, right to sleep, freedom from noise pollution, right to sustainable development, right to opportunity, right to a decent burial, cremation.
The right to sleep.
Yeah.
The right to a decent burial. That is an astonishingly broad and diverse list. It really shows how the Supreme Court has used that Maneka Gandhi interpretation of Article 21 as this dynamic tool to protect rights, considered essential for a dignified life in the evolving context of Indian society.
It absolutely highlights the judiciary's role in trying to make the right to life and liberty meaningful in the face of new challenges and changing societal norms. And notably, one of the rights recognized by the court under Article 21, the right to education, was later given its own separate, explicit fundamental right status.
Right, Article 21A, right to education.
Yes, Article 21A was put in by the 86th Constitutional Amendment Act in 2002. It mandates that the state shall provide free and compulsory education to all children aged 6 to 14 years in whatever manner the state determines by law.
So elementary education for that specific age group became a full-fledged, enforceable, fundamental right, not just a goal.
Correct. This was a very significant step, often called the dawn of the Second Revolution for educational rights. Before this amendment, free and compulsory education was mainly a directive principle under the original Article 45, which, being a directive principle, wasn't directly enforceable by courts. Elevating it to a fundamental right made it justiciable.
And the 86th Amendment also adjusted the original Article 45 and added a fundamental duty related to education, didn't it?
Yes, the amendment changed Article 45, which now directs the state to try and provide early childhood care and education for all children until they turn 6. It also added Clause K to Article 51A, making it a fundamental duty of every parent or guardian to provide opportunities for education to their child or ward between 6 and 14 years old.
So a three-pronged approach: state responsibility under Article 21A and the revised 45, and citizen duty under 51AK. You mentioned the Supreme Court had already recognized a right to education under Article 21 before the amendment.
Yes, in the Unikrishnan case in 1993, the Supreme Court had held that the right to education up to age 14 is a fundamental right under Article 21. It clarified that beyond 14, the right depends on the state's economic capacity. This judgment modified the earlier Mohini Jain case, 1992, which had suggested a fundamental right to education at any level. The 86th Amendment essentially gave constitutional force to the Unikrishnan ruling for elementary education.
And Parliament passed a law to implement Article 21A.
Yes, the right of children to free and compulsory education, RTE Act 2009, was passed to provide the legislative framework. It aims to ensure every child in the 6-14 age group gets full-time elementary education of satisfactory quality in a formal school meeting certain norms and standards. The act is based on the belief that inclusive elementary education is crucial for equality, social justice, democracy, and a humane society. Both the 86th Amendment and the RTE Act came into force together on April 1, 2010.
That's a very concrete step, making access to basic education a legal reality for millions. Okay, finally, in this section on freedom, Article 22 provides protection against arrest and detention.
Article 22 gives certain safeguards to people who are arrested or detained. As your source notes, the article makes a distinction between two kinds of detention: punitive detention and preventive detention.
Punitive detention being punishment after a trial and conviction, and preventive detention being detention without trial, based just on suspicion.
Exactly. Punitive is punishment for an offense committed after trial and conviction. Preventative is detention without trial. As a precaution, based on suspicion, someone is likely to commit a future offense. Article 22 is split into two parts, providing different sets of rights for these two situations. Part 1 deals with people arrested or detained under ordinary law. This mainly covers punitive detention after arrest but before trial. It grants 4 key rights. First, the right to be informed of the grounds of arrest as soon as possible. Second, the right to consult and be defended by a legal practitioner of their choice.
Essential.
Third, the right to be produced before the nearest magistrate within 24 hours of arrest, not counting travel time.
Right.
Fourth, the right to be released after 24 hours unless the magistrate authorizes further detention.
These are absolutely essential rights for anyone arrested under normal law, making sure they're informed, have legal help, and see a judge quickly.
Yes, fundamental due process safeguards. However, these safeguards are not available to two groups: an enemy alien and a person arrested or detained under a preventive detention law. The Supreme Court has also said these rights don't apply to detention ordered by a court, civil arrest, arrest for not paying tax, or deportation of an alien. They apply mainly to arrests of a criminal or quasi-criminal nature or related to activities against public interest.
Okay, so specific types of detention, and especially those under preventive detention laws, are excluded from these particular safeguards. What protections do people under preventive detention laws get under Part 2 of Article 22?
Part 2 provides some, though definitely less expensive, protections for people under preventive detention. These apply to both citizens and aliens. The safeguards are: first, detention cannot exceed 3 months unless an advisory board reports sufficient cause for longer detention. The board must consist of high court judges or former judges. Note, the 44th Amendment tried to reduce this period to 2 months, but that specific provision never came into force, so 3 months remains the limit without board approval. Second, the grounds for detention must be communicated to the person detained as soon as possible. However, the authorities can withhold facts if they think disclosing them would be against the public interest. Third, the detained person must be given the earliest opportunity to make a representation against the detention order.
So, a limited review by an advisory board, notification of grounds with possible exceptions withheld, and a chance to make your case. It's a significantly less robust set of protections compared to those arrested under ordinary law.
It is. Article 22 also gives Parliament the authority to legislate on certain aspects of prevented detention, like the circumstances where detention can exceed 3 months without board opinion, the maximum period of detention, and the procedure for the advisory board. The power to make preventive detention laws is divided. Parliament has exclusive power for reasons related to defense, foreign affairs, and India's security. Both Parliament and state legislatures have concurrent power for reasons related to state security, public order, and essential supply services.
And your source mentions various preventive detention laws enacted by Parliament over the years, showing this power has been used continuously.
Yes, examples include COFEPOSA, Smuggling Foreign Exchange, NASA, National Security Act, and UAPA, Unlawful Activities Prevention Act. Older laws, now repealed, included MISA, TADA, and POTA. This list shows the power has been used repeatedly by different governments for security and public order reasons.
This whole aspect of Article 22, allowing preventive detention within the chapter on fundamental rights, is often a point of major criticism, as noted in your source.
It is a major point of contention. Critics see including preventive detention as an integral part of the Constitution as highly problematic, a significant blot on the fundamental rights chapter. They argue no other democratic country has such a provision as a normal feature. It's unknown in the USA, used only temporarily in Britain during wars. The critique is it gives arbitrary power to the state and fundamentally negates individual liberty, the very essence of fundamental rights. Some argue its inclusion makes the Indian Constitution seem more concerned with state rights against the individual than individual rights against the state. Its historical roots are often traced to similar powers used by the British in colonial India.
That's a powerful criticism, having a constitutional provision allowing detention without trial, sitting right inside the framework designed to protect liberty, feels inherently contradictory to many observers.
It certainly presents a significant tension within the scheme of fundamental rights.
Okay, moving on from freedom, let's explore the right against exploitation, covered in Articles 23 and 24. Article 23 prohibits traffic in human beings and forced labor.
Article 23 targets practices that degrade human dignity and exploit the vulnerable. It explicitly prohibits traffic in human beings, BR, that specific Indian form of forced labor without pay, and other similar forms of forced labor. It declares any violation as an offense punishable by law.
And this, right, like Article 17 on untouchability, protects against both the state and private individuals, correct?
Yes, it applies to everyone, citizens and non-citizens, and protects them from the state and private persons. Traffic in human beings is interpreted broadly, selling, buying humans. Immoral traffic like prostitution, though regulated by law, the Devadasi system, slavery. Parliament passed the Immoral Traffic Prevention Act, 1956, to tackle this.
And bigar and forced labor.
Vigara specifically refers to compulsory work without pay, historically linked to the zamindari system. Forced labor is broader, compelling someone to work against their will. A key judicial interpretation expanded force here. It's not just physical or legal force, but also economic compulsion. For example, forcing someone to work for less than the minimum wage could be considered forced labor under this article. Related laws include the Bonded Labor System Abolition Act, 1976, Minimum Wages Act, 1948, etc.
So working for exploitative below minimum wages can actually fall under the definition of forced labor. That's a very significant interpretation. Is there any exception to this broad prohibition?
Yes, one exception. Article 23(2) allows the state to impose compulsory service for public purposes, like military service or social service. When doing so, the state isn't required to pay. However, a crucial condition is that the state cannot discriminate only on grounds of religion, race, caste, or class when imposing such service.
Okay, so compulsory service for the collective good is allowed, provided it's non-discriminatory and for a public purpose. Article 24 focuses specifically on children and employment.
Article 24 is a specific safeguard for children. It prohibits employing children below the age of 14 years in any factory, mine, or any other hazardous activity like construction or railways. But, importantly, it does not prohibit their employment in harmless or innocent work.
This is clearly aimed at protecting young children from dangerous or harmful working conditions.
Absolutely. To enforce this, Parliament enacted the Child Labor Prohibition and Regulation Act, 1986, later renamed the Child and Adolescent Labor Act, 2016. Other laws also address child labor. The Supreme Court has been active here too, issuing directives in a 1996 case for rehabilitating child laborers, including setting up a welfare fund financed by employer fines and directing measures for child education, health, and nutrition.
And the government also expanded the ban through executive action, didn't it?
Yes, in 2006, the government banned employing children under 14 as domestic servants or in businesses like hotels, dhabas, etc. Violators face prosecution under the act. The Commissions for Protection of Child Rights Act, 2005, also set up national and state commissions and children's courts to speed up trials for offenses against children, further strengthening protections.
Clear constitutional protection and ongoing legal and judicial efforts to tackle child labor. That covers the right against exploitation. Next, the right to freedom of religion, Articles 25 through 28. In a country as religiously diverse as India, this is undoubtedly a fundamental set of rights.
Absolutely. India is a secular state, and freedom of religion is a cornerstone. Article 25 is the main one here, granting freedom of conscience and the right to freely profess, practice, and propagate religion. This right applies to all persons, citizens, and non-citizens alike.
Let's break down those key terms in Article 25. Profess, practice, propagate.
Okay. Freedom of conscience is the inner freedom to relate to God or spirituality as you wish. Right to profess means openly declaring your beliefs. Right to practice includes worship, rituals, ceremonies, displaying beliefs. Right to propagate means transmitting or spreading your beliefs to others.
That right to propagate is sometimes controversial. Does it include a right to convert others?
The Supreme Court has clarified this. The right to propagate does not include the right to convert another person using force, fraud, or inducement. The court said while you can share your beliefs, forcing or tricking someone into converting impinges on their freedom of conscience, which is equally protected. Propagation is seen more as sharing beliefs, hoping others might voluntarily accept them.
So sharing beliefs is protected, but not forced conversion. Got it.
Correct. Article 25 protects both religious beliefs, doctrines, and practices, rituals. However, these rights aren't absolute. They are subject to limitations mentioned right in Article 25. Public order, morality, health, and other fundamental rights.
That limitation based on other fundamental rights is quite notable.
Yes, it means your religious freedom can't violate others' fundamental rights, like equality or life liberty. Furthermore, the state is permitted to regulate or restrict any economic, financial, political, or other secular activity associated with religious practice. The state can also provide for social welfare and reform, and can throw open Hindu religious institutions of a public character to all classes and sections of Hindus.
So activities linked to religion but secular in nature can be regulated, and social reform laws are allowed even if they impact religious practices.
Exactly. The state can intervene in secular aspects and legislate for social reform. Article 25 also has two explanations. Explanation 1 clarifies that wearing and carrying kirpans is part of the Sikh religion. Explanation 2 clarifies that Hindus, for the purpose of opening institutions, includes Sikhs, Jains, and Buddhists, and Hindu religious institutions covers theirs too.
That clarifies specific practices for Sikhs and includes Jains and Buddhists under the Hindu umbrella for accessing public religious institutions.
Okay. Article 26 deals with the collective freedom of religion for denominations.
Yes, while 25 is individual, Article 26 grants rights to every religious denomination or any section thereof. These are about managing religious affairs collectively.
What rights do religious denominations have under Article 26? A religious denomination or its section has the right, first, to establish and maintain institutions for religious and charitable purposes. Second, to manage its own affairs in matters of religion interpreted as core religious rights and practices. Third, to own and acquire movable and immovable property. Fourth, to administer such property in accordance with law, meaning property administration must follow general property laws.
Are these collective rights also subject to limitations?
Yes, Article 26 rights are subject to public order, morality, and health. Notably, unlike Article 25, they aren't explicitly subject to other fundamental rights in the text. The Supreme Court has had to define religious denomination. The criteria are a collection of individuals with a shared belief system for spiritual well-being, a common organization, and a distinctive name. Based on this, the SC found Ramakrishna Mission and Ananda Marga are Hindu denominations, but the Aurobindo Society is not.
That provides a framework for identifying groups that can claim these collective rights. Article 27 deals with freedom from taxation for promoting religion.
Article 27 is another crucial part of India's secularism. It says no person shall be compelled to pay taxes, where the proceeds are specifically used for promoting or maintaining any particular religion or denomination.
So the state can't use tax money to favor one religion over others.
Exactly. The state can use tax money to support all religions generally, but can't levy taxes specifically for one. It prohibits a tax levy, but not a fee. A fee is different. It's usually for a service or to cover regulation costs, not general revenue or religious promotion. Fees can be levied on pilgrims for service safety or on religious endowments to cover regulation costs.
Okay, so funding specific services or regulation is distinct from using general tax revenue to boost a particular faith. Article 28 deals with religious instruction in educational institutions.
Article 28 regulates religious instruction depending on how institutions are funded or managed. It sets rules for 4 types. First, institutions wholly maintained by state funds. No religious instruction allowed, period. Second, institutions administered by the state, but set up under an endowment trust that requires religious instruction. Here, the ban doesn't apply. Religious instruction is permitted. Third, institutions recognized by the state. Fourth, institutions receiving aid from the state. For these last 2 categories, religious instruction may be permitted.
So for state-recognized or state-aided institutions, is attending that religious instruction compulsory if it's offered?
No, and this is a key safeguard. For institutions only recognized or aided by the state, instruction is permitted, but it's strictly voluntary. No one attending can be required to attend religious instruction or worship unless they, or their guardian if they're a minor, have given consent.
That provides different levels of separation between state and religion and education, depending on funding and management, while ensuring voluntary participation where it's allowed. Okay, that covers freedom of religion.
Next, we look at cultural and educational rights in Articles 29 and 30. These primarily aim to protect minority interests, although one has a potentially broader scope.
Article 29 focuses on protecting minority interests.
Article 29 has 2 parts. First, any section of the citizens residing in India with a distinct language, script, or culture has the right to conserve it. Second, no citizen shall be denied admission into any educational institution maintained by the state or receiving state aid on grounds only of religion, race, caste, or language.
So the first part protects the group right to preserve a distinct identity, language, script, culture. And the second protects the individual citizen against discrimination in admission to state or state-aided institutions based on religion, race, caste, or language.
Correct. The first protects a collective right, the second individual right. Article 29 protects both religious minorities and linguistic minorities.
Your source notes that the scope of that first provision isn't strictly limited just to minorities.
That's based on judicial interpretation. While the heading mentions minorities, the Supreme Court has said the phrase any section of the citizens in Article 29(1) means its scope isn't necessarily restricted only to minorities. It could potentially include sections of the majority too, although the main aim is clearly protecting minority interests. The right to conserve language under 29(1) has also been interpreted to include the right to agitate, even politically, for language conservation.
An interesting interpretation potentially extending the scope. Article 30, however, is explicitly about the rights of minorities, right?
Yes, Article 30 grants specific rights confined only to religious and linguistic minorities. First, it gives all religious and linguistic minorities the right to establish and administer educational institutions of their choice. This is crucial, allowing them to set up and run institutions according to their preferences, perhaps teaching in their own language or promoting their culture or religion. Second, a significant provision added by the 44th Amendment. When the state compulsorily acquires property of a minority educational institution, the compensation amount must be such that it doesn't restrict or take away this right under Article 30. This was added to prevent the state from undermining the right by offering peanuts for property, especially after the general right to property was removed from FRs.
A safeguard for their viability.
Exactly. Third, the state shall not discriminate against any minority-managed educational institution when granting aid, whether based on religion or language.
So Article 30 gives religious and linguistic minorities specific rights to establish and run their own educational institutions without state discrimination in aid, and with protection against unfair compensation if their property is acquired.
Precisely. The term minority isn't defined in the Constitution, but Article 30's protection is clearly for religious and linguistic minorities. The right includes imparting education in their own language. Your source outlines how state regulation differs depending on whether these institutions seek state recognition or aid.
What are those different types and how does regulation apply?
Essentially 3 types. First, those seeking both recognition and aid from the state. Second, those seeking only recognition, not aid. Third, those seeking neither recognition nor aid.
Right.
Institutions in the first 2 categories, seeking recognition or aid, are subject to state regulation on things like syllabus, academic standards, discipline, staff appointments, etc. These regulations are allowed to ensure educational quality and efficiency. Institutions in the third category, seeking neither, are largely free to administer themselves, but still subject to general laws like contract law, tax law, labor law.
So accepting state recognition or aid brings some state regulation for standards seen as legitimate. The Supreme Court provided a summary of principles for these institutions.
Yes. In the Secretary of Malankara's Syrian Catholic College case, 2006, the SEC consolidated key principles for Article 30. The court affirmed the right to administer includes choosing the governing body, appointing staff, admitting students, setting reasonable fees, using property. But, the court emphasized, Article 31 aims to ensure equality with the majority, not put minorities in a better position or allow reverse discrimination.
So it's a right to parity, not superiority or complete insulation from rules.
Exactly. The court stressed the right to administer doesn't include the right to maladminister. Reasonable state regulations are okay to ensure educational character, standards, efficiency, and prevent mismanagement. For example, teacher qualifications, service conditions, syllabus. Even unaided institutions must meet state criteria for staff appointments. Receiving aid doesn't change the institution's minority character, but conditions can be put on aid use, provided they don't undermine the core Article 31 right.
That provides a very clear framework balancing minority institution rights with legitimate state regulation for quality education.
Now that we've covered the specific categories of fundamental rights, we finally return to the article that gives real teeth to all of them. The right to constitutional remedies, Article 32.
This is arguably the most critical article in the entire chapter, isn't it?
It really is. As your source states, just listing rights isn't enough. Their value comes from enforceability. Article 32 makes the fundamental rights real by giving the right to move the highest court for enforcement if they're violated. The right to get your fundamental rights protected is itself a fundamental right.
This is where Dr. B.R. Ambedkar's famous quote comes in, about it being the heart and soul.
Yes, Dr. Ambedkar called it the most important article, without which this Constitution would be a nullity. The very soul of the Constitution and the very heart of it. That really highlights its perceived importance. The Supreme Court has echoed this, ruling Article 32 is a basic feature of the Constitution, meaning it can't be taken away even by amendment under the basic structure doctrine.
Placing it firmly in the unamendable core, cementing its role as protector of the other rights. What are the specific provisions of Article 32?
It has 4 key provisions. First, the right to move the Supreme Court by appropriate proceedings for enforcing the rights in Part 3 is guaranteed. Direct access. Second, the Supreme Court is empowered to issue directions, orders, or writs, habeas corpus, mandamus, prohibition, certiorari, quo warranto for enforcing fundamental rights. These writs are the main tools.
Right.
Third, Parliament can empower other courts to issue these writs locally, but hasn't done so beyond the high courts, who have their own power under Article 226. Fourth, The right guaranteed by Article 32 cannot be suspended, except as provided by the Constitution, referring to the President's power during a national emergency under Article 359.
So the Supreme Court is the designated defender and guarantor, equipped with original and wide powers, including issuing these various writs. Original jurisdiction meaning you can go straight there.
Exactly. The purpose is a guaranteed, effective, quick, inexpensive summary remedy. But it's crucial to understand, Article 32 can only be invoked for enforcing fundamental rights in Part 3, not other legal rights like statutory or customary rights.
So a violation of a fundamental right is the necessary trigger to go directly to the Supreme Court under Article 32. You can't just use it to challenge any law's constitutionality unless it directly infringes an FR.
Precisely. And while the Supreme Court's jurisdiction under Article 32 is original, it's not exclusive. The high courts also have original powers to issue these writs under Article 226. The key difference, as you noted, is scope. High courts can issue writs for enforcing FRs plus any other purpose, i.e. other legal rights. This makes the High Court's writ jurisdiction technically wider in subject matter than the SCs under Article 32.
Ah, that's a critical distinction. HCIs under 226 cover FRs and other legal rights, while SC under 32 only covers FRs.
Correct. If your fundamental right is violated, you can choose to go to the High Court, Art 226, or the Supreme Court, Art 32. While having the HEIC option isn't technically a bar to using Art 32, since Art 32 is itself an FR, the Supreme Court generally prefers people approach the High Court first, especially if similar relief is available there. Seems practical.
Makes sense for managing the SC's workload. You mentioned the 5 types of writs: habeas corpus, mandamus, prohibition, certiorari, quo warranto. These are the specific tools the courts use. Can you briefly explain what each one does?
Sure. These are powerful prerogative writs from English law. First, habeas corpus, literally to have the body, in order to someone detaining another person to produce that person before the court. The court checks if the detention is legal. If illegal, the person is freed. It's a key defense against arbitrary detention, usable against public authorities and private individuals, not issued if detention is lawful for contempt by a competent court or outside jurisdiction.
A powerful check on illegal imprisonment.
Absolutely. Second, mandamus means we command. A command to a public official, body, corporation, lower court, or tribunal to perform a public or statutory duty they've failed or refused to do. It compels them to act. Can't be used against private individuals' bodies for non-statutory instructions, discretionary duties, or contractual obligations. Also not against the president, governors, or a high court chief justice acting judicially.
A way to make public authorities do their job.
Yes. Third, prohibition means to forbid. Issued by a higher court to a lower court tribunal to stop it from exceeding its jurisdiction or acting without jurisdiction. It directs inactivity. Only against judicial or quasi-judicial bodies, not against administrative, legislative, or private bodies. Issued before a final order to prevent the illegality.
Means to be certified or to be informed. Issued by a higher court to a lower court tribunal to transfer a case, or, more commonly, to quash an order already passed. Grounds are excess lack of jurisdiction or error of law on the face of the record. Like prohibition, it's jurisdictional and only against judicial quasi-judicial bodies. Key difference. Certiorari is issued after the final order to quash it. Prohibition is before to stop it.
So prohibition stops it before it finishes. Certiorari quashes it after it's done, both dealing with jurisdictional errors.
Precisely. Fifth, quo warranto, means by what authority or warrant. Used to inquire into the legality of someone's claim to a public office. Asks the office holder to show their legal authority. If they lack it, the court prevents them from holding the office. Stops illegal usurpation. Only for substantive public offices, permanent, created by statute constitution, not ministerial private ones. Uniquely, any interested person can seek this writ, not just someone personally aggrieved.
That's interesting. Any citizen can challenge if someone's legally holding a public office. These writs are clearly potent tools for the judiciary to ensure legality and protect rights.
They are the specific mechanisms making the justiciability of fundamental rights effective.
Now, we've touched on them, but let's look closer at the specific limitations on FRs in Articles 33, 34, and 35. Article 33 concerns the armed forces and related groups.
Right. Article 33 gives Parliament the power to make laws restricting or even abrogating the fundamental rights of members of the armed forces, paramilitary forces, police forces, intelligence agencies, and similar forces. The purpose is clearly stated: to ensure they discharge their duties properly and maintain discipline.
And this power is exclusively with Parliament.
Yes, only Parliament, not state legislatures. And crucially, a law made by Parliament under Article 33 cannot be challenged in court on the ground that it violates any fundamental right.
So their rights can be constitutionally limited for discipline and duty, and that limitation is specifically shielded from FR-based judicial review.
Correct. Examples of restrictions imposed under such laws include curbing their freedom of speech, for example, criticizing policy, assembly, service-related meetings, association, joining unions, political groups, restricting communication with the press, etc. Members includes even non-combatant employees like barbers or mechanics. A law under Art 33 can even exclude court-martial decisions from SCHC writ jurisdiction regarding FR enforcement.
Significant limits, but deemed necessary for these disciplined forces. Article 34 deals with martial law.
Article 34 provides for restrictions on FRs, while martial law is enforced in any area. It also empowers Parliament to pass an Indemnity Act to protect government servants or any person for acts done during martial law to restore order. It can also validate sentences, punishments, forfeitures under martial law. An Indemnity Act under Art 34 is explicitly immune from FR challenge.
So it allows extraordinary measures, including infringing rights, to restore order under martial law, and then Parliament can validate those actions afterwards, shielding them from FR challenges. You mentioned martial law is different from a national emergency. Can you quickly recap the key differences from the source?
Sure, the source highlights.
Martial law affects only FRs. National emergency, R352, affects FRs, center-state relations, legislative, financial, potentially Parliament's tenure, much broader.
Martial law suspends ordinary gov courts. Military takes over. National emergency sees ordinary gov courts continue functioning.
Martial law is for restoring order broken down for any reason: war, rebellion, riot, etc. National emergency only on 3 grounds: war, external aggression, armed rebellion.
Martial law is localized to a disturbed area. National emergency can be nationwide or partial.
Martial law is only implicitly recognized in Art 34. National emergency has explicit, detailed provisions, Art 352+.
That clarifies martial law as a temporary, localized military takeover for order versus a national emergency as a broader constitutional response to specific threats where civilian government continues.
Exactly. And finally, Article 35 consolidates Parliament's power regarding laws to implement certain FRs. Article 35 reinforces that the power to make laws giving effect to certain specified FRs rests only with Parliament, not states, ensuring uniformity. The matters covered are prescribing residence conditions, Art 16, empowering other courts for writs, Art 32, restricting FRs for armed forces, etc., Art 33, and indemnifying during martial law, Art 34.
And it also covers Parliament's exclusive power to prescribe punishment for FR offenses.
Yes. Article 35 says Parliament alone has power to make laws prescribing punishment for acts declared offenses under FR specifically, untouchability, Art 17, and traffic forced labor, Art 23. It's obligatory for Parliament to make such laws, ensuring uniform punishment nationwide.
So even if aspects of untouchability or forced labor touch on state-list matters, Article 35 gives Parliament exclusive power for punishments under these FRs, ensuring consistency.
Correct. Art 35 extends Parliament's power here, overriding state-list boundaries for these specific FR-related laws. It also says existing laws on these matters continue until Parliament changes them.
Okay. That brings us back full circle, almost, to the right to property. We touched on its deletion from Part 3, but given its controversial history and the amendments, it's worth quickly reviewing its current status and the implications of that change.
Right. As we discussed, it was originally an FR under Article 19(1), citizens' right to acquire, hold, dispose property, and Article 31, protection against deprivation without law plus compensation for acquisition. It was by far the most controversial FR, causing huge friction between the SC and Parliament,
Leading to that flurry of constitutional amendments trying to facilitate land reforms and other measures.
Exactly. The 1st, 4th, 7th, 25th, 39th, 40th, 42nd Amendments, plus Articles 31A, 31B, 31C, were largely responses trying to shield laws, especially property land reform laws, from being struck down. Compensation was often the sticking point. This long battle ended, effectively, with the 44th Amendment Act of 1978.
Which abolished the right to property as a fundamental right.
Yes. The 44th Amendment repealed Article 19(1) and Article 31 from Part 3. It then inserted a new article, Article 300A, in Part 12, right to property, which simply says, no person shall be deprived of his property save by authority of law.
So it's still a right, a constitutional or legal right, but crucially not a fundamental one. What are the practical consequences of losing that fundamental status?
They're significant. First, being just a legal constitutional right, it can be regulated or changed by an ordinary law of Parliament, not needing a constitutional amendment. Much easier for the state to legislate. Second, Article 300A protects against arbitrary executive action. Gosh, we can't just take property without a law. But it does not protect against legislative action. If Parliament passes a law for acquisition, that law provides the authority of law, making the action permissible under 300A. Third, you can't directly go to the Supreme Court under Article 32 if this right is violated. You have to use Article 226 in the High Court or file a regular suit. Fourth, and very importantly, there's generally no guaranteed right to compensation if the state acquires property under Article 300A. Compensation, if any, depends on the ordinary law authorizing the acquisition.
So losing fundamental status meant losing direct SC access and losing the constitutional guarantee of compensation that Article 31 provided.
Exactly. It significantly reduced the protection for property rights compared to the original Constitution. However, it's important to remember, despite removing the general FR to property, there are still two specific exceptions in Part 3, where compensation is constitutionally guaranteed at market value. First, when the state acquires property of a minority educational institution, under Article 30 as amended. Second, when the state acquires land under personal cultivation within statutory ceiling limits, under Article 31A.
So while the general right is now a lesser legal right, these two specific scenarios still get the higher protection of guaranteed compensation under provisions linked to fundamental rights.
Yes, reflecting specific concerns deemed important enough for that higher protection. And Articles 31A, 31B, and 31C, born from the property controversies, were kept even after the main right moved out of Part 3.
Right. These articles shield certain laws from FR challenge, mainly Articles 14 and 19. Let's quickly recap what each one does.
Okay. Article 31A, added by First Amendment, saves 5 categories of laws related to agrarian reforms, taking over management, amalgamation, modifying director shareholder rights, modifying mining leases, from challenge under Articles 14 and 19, aimed at facilitating socioeconomic reforms. Needs President's assent for state laws. Article 31B, added with the 9th Schedule by First Amendment, a powerful shield, validates acts regulations put in the 9th Schedule, saving them from challenge under any FR broader than 31A.
But the absolute immunity of 31B in the 9th Schedule was curtailed by the judiciary.
Yes, significantly. The SC in Kesavananda Paradi, 1973, ruled 9th, schedule laws are challengeable if they violate the basic structure. In Walman Rao, 1980, it clarified laws added before the Kesavananda date, April 24, 1973, get full immunity, but laws added after that date are challengeable if they damage the basic structure.
So Kesavananda became the dividing line from the 9th Schedule immunity.
Correct. Affirmed again in IR Koidu 2007. No blanket immunity for post-1973 additions. Judicial review is basic feature. Laws added after April 24, 1973 are challengeable if they violate Art 14, 15, 19, 21, or the basic structure. So the 9th Schedule isn't an absolute shield anymore for laws added after that date. It has grown from 13 acts to 282 now, mostly state land laws. Article 31C, inserted by 25th Amendment, aimed to give DPs primacy over FRS version 1. No law implementing socialist DPs in Art 39BC, resource distribution, preventing wealth concentration, void for contravening Art 14 or 19. Original version also had a clause saying a declaration of the law that it's for such policy couldn't be questioned in court.
And the court struck down part of this too.
Yes, in Kesavananda, 1973, SC upheld the first part, saving laws implementing 39BC from Art 1419 challenge, but struck down the second part, barring judicial review of the declaration, as violating the basic feature of judicial review. Later, the 42nd Amendment tried to expand 31C to protect laws implementing any DP from Art 1419 challenge.
Which the Supreme Court also struck down.
Yes. In Minerva Mills, 1980, SC declared that expansion unconstitutional. So 31C's protection remains limited to laws implementing only Art 39B and 39C, and state laws need President's assent.
That brings us through the specific exceptions and limitations. So while fundamental rights are clearly powerful, their application and enforcement are really complex, shaped by these specific constitutional provisions and layers of judicial interpretation.
Indeed. They operate within a carefully defined, though sometimes contested, framework, not in an absolute vacuum.
Now let's turn to the critiques. Your source material highlights that despite their obvious significance, the fundamental rights aren't without their critics. What are some of the main points raised against them?
Yes, While vital, the FR chapter has faced several criticisms over the years. First, excessive limitations. A common point is that the rights are subject to just so many exceptions, restrictions, qualifications, explanations. Critics argue the Constitution seems to give with one hand and take away with the other through these limits. Some even suggested the chapter should be called Limitations on Fundamental Rights.
We have certainly seen a lot of provided that clauses and grounds for restriction built right into the articles.
Exactly. The balance is key, but critics feel the restrictions are too heavy. Second, no social and economic rights. The list is mainly political rights, civil liberties. Critics point out the lack of crucial social economic rights often found elsewhere: right to Social Security, work, employment, rest, leisure. These are mostly in the non-justiciable directive principles.
So rights related to basic needs and economic well-being don't have that same fundamental enforceable status.
Precisely. Third, lack of clarity. Critics argue the language used is often vague, indefinite, ambiguous. Terms like public order, minorities, reasonable restriction, public interest aren't precisely defined. This leads to extensive, complex judicial interpretation, made the Constitution seem like it was by lawyers for lawyers. Sir Ivor Jennings famously called it a paradise for lawyers due to the scope for litigation.
The need for so much judicial interpretation does suggest the original text might not be crystal clear for the average person.
That's the criticism. Fourth, no permanency. They aren't sacrosanct. As the right to property showed, Parliament can curtail or abolish them via amendment. Critics worry this makes them vulnerable, a potential play tool for politicians with a majority. The basic structure doctrine is the only real check on this.
The potential for amendment does seem to challenge the idea of them being permanent or truly fundamental in an absolute sense.
Indeed. Fifth, suspension during emergency. The provision to suspend FRs, except 2021, during a national emergency is seen by critics as a major blot. They argue it undermines democracy and jeopardizes rights when they might be needed most, suggesting FRs should always be enjoyable.
Even with the exceptions for life liberty, suspending many freedoms during an emergency is seen as deeply problematic.
It's seen as a huge curtailment when checks on power are vital. Sixth, expensive remedy. While the judiciary protects FRs, accessing courts, especially higher courts, is expensive. Costs can prevent ordinary people from getting rights enforced. Critics say this means FRs mainly benefit the wealthy.
Access to justice is key, and financial barriers undermine that access significantly.
A very practical point. Seventh, preventive detention. As we discussed under Article 22, including preventive detention in the FR chapter is heavily criticized. Critics say it grants arbitrary state power, negates liberty, and is fundamentally against the spirit of FRs. They find it concerning that it's a unique, integral feature among democracies, perhaps reflecting a bias towards state power over individual freedom, maybe from colonial history.
This specific provision is highlighted as being fundamentally at odds with the chapter it's in.
Often cited as a constitutional anomaly. Eighth, no consistent philosophy. Some critics, like Sir Ivor Jennings, argue the FR chapter isn't based on a single consistent philosophy, more like a patchwork. They suggest this lack of a clear guiding principle makes interpretation harder for courts.
So criticisms cover the substance, limits, scope, the form, clarity, permanence, suspension, enforcement, cost, preventive detention, and even the philosophical basis.
Those are the main critiques detailed in your source, giving a balanced perspective.
Okay. Despite these significant criticisms, the source also strongly emphasizes the profound significance of fundamental rights in the Indian constitutional setup. What makes them so vital, despite the critiques?
Yes. While the critiques are important, the significance is immense. They're crucial for several reasons. First, they form the very bedrock of India's democratic system. Without them, democracy is meaningless. Second, they provide necessary conditions for the material and moral protection and development of people, essential for individual flourishing.
Right.
Third, they serve as a formidable bulwark of individual liberty, protecting citizens from state overreach. Fourth, they facilitate the rule of law by ensuring government action is subject to constitutional limits and legal checks. Fifth, they play a vital role in protecting minority interests and weaker sections, safeguarding against discrimination and ensuring inclusion. Sixth, they strengthen India's secular fabric by guaranteeing freedom of religion and protecting minority cultural educational rights, ensuring no state religion and equal respect for all faiths. Seventh, they check the absoluteness of government authority, limiting both executive and legislative power, ensuring governance isn't arbitrary. Eighth, they lay the foundation for social equality and social justice, especially through provisions on equality, non-discrimination, abolishing untouchability, and forced labor.
So even with all the complexities and criticisms, their role in upholding democracy, liberty, equality, and justice as core constitutional values is absolutely undeniable.
Absolutely. Their presence fundamentally shapes the relationship between the citizen and the state in India.
So where does that leave us? We've taken a pretty deep dive into Part 3 of the Indian Constitution, exploring the origins, the evolution, the specific articles, their inherent limitations and exceptions, and also looked at the critiques versus the undeniable significance of these fundamental rights.
We've seen how they aim to protect individual liberty, promote political democracy, and place crucial limits on the power of the state. We've also acknowledged the complexities, those built-in qualifications, and the historical context of how they've evolved through amendments and judicial interpretations, often responding to societal needs and political pressures, as your source material laid out.
We've highlighted specific rights like the multifaceted right to equality, that huge bundle of freedoms under Article 19, and especially the ever-expanding Article 21, the protections against exploitation, the delicate balance of religious freedom, and the cultural educational rights for minorities. And of course, that absolutely vital right to constitutional remedies under Article 32 that makes the others actually mean something. The journey through key court cases, Goklan, Maneka Gandhi, Mandal, Kesavananda Parati, I.R. Coelho, it really shows these aren't just static rules, but living principles constantly being interpreted and redefined.
It is truly fascinating to see how a framework inspired by documents centuries old, like Magna Carta and the U.S. Bill of Rights, has been adapted, built upon, and expanded so extensively in the unique context of India. Dealing with immense diversity, historical injustices like untouchability, and that complex ongoing balance between individual rights and the state's role in pursuing social and economic justice, for instance, through reservations.
Absolutely. And that balance, particularly the role of judicial interpretation, brings us to a really interesting point for reflection, something to perhaps leave you thinking about. Considering how the Supreme Court has interpreted the right to life and personal liberty under Article 21 to include such an incredibly wide array of rights, from a pollution-free environment to the right to sleep, or the right to privacy, does this extensive judicial expansion reflect a necessary adaptation? Adapting constitutional principles to the evolving needs and complexities of modern society to ensure a truly meaningful life with dignity today.
Or, on the other hand, does it risk stretching the meaning of life and personal liberty, perhaps too far, potentially diluting the core intent of the original article as the framers saw it? Does it create uncertainty, or maybe even risk the judiciary stepping too far into what might be seen as policy-making territory?
It's certainly something to mull over, the implications of that judicial dynamism. Where's the right balance? Anyway, something for you to consider as you reflect on this deep dive into the fundamental rights of the Indian Constitution. Thanks for joining us.
Until next time.